Stanford University.
This presentation is delivered by the Stanford Center for Professional Development.
All right, we're going to get started. I had a chance to obviously review all of and grade all of the provisional applications that you guys did. I had a couple of just kind of general comments, and so that might be useful for you guys as you move forward. Again, we're moving to a first-to-file system, and when we move to a first-to-file system, being first is going to matter. And to be first, it'd be great to be able to bypass the patent attorney and the patent attorney process altogether. It comes out of your brain, you invent it, and then later that day, later that week, next week, you actually file for a provisional application. You guys know what to do now, and for the most part, the provisional applications are great. I was really excited about the quality of the work. A couple of comments. Again, even though I had talked about it, there's still a decent amount of discussion in background sections and kind of summary sections. But specifically, the background section is what I want to talk about. It's not required. There is absolutely nothing in the patent application process that requires a background section. Every single statement that you make under the heading background is going to be assumed that that is well known in the art. And that is now an admission. And so if you say something along the lines of, there is a need to do this, you have now admitted that there is a need in the art to do this. And if your invention is more on the discovery of the need side rather than the solution side, but actually the problem side, then you've just admitted that there is a need to do this. And so therefore your invention is now patentable. And every single thing that you say from that statement on doesn't matter, because you've just shot yourself in the foot. Background sections, especially in provisionals, aren't going to be helpful ever. I still write very, very small background sections, but I'm very careful with the need concept that I talk about, in the sense that every single sentence in that background section I think about, am I fine if every single one of the sentences is now an admission? That thing's blown up on a screen in the middle of a judge and jury and in the middle of a courtroom, and they get to see that, and that's now my admission, and I'm fine with that statement. So talking about the prior art isn't going to help in a provisional. You'll actually learn a heck of a lot more about the prior art when you start to convert it from a provisional to a full application. Now you'll be able to see another 12 months of prior art. Prior art patent applications are published after 18 months. And so if you were to try to do a prior art search at the provisional stage, you can't see 18 months back. But if you wait 12 months to do that patent search, now you can see 2/3 of that window. So I don't actually even do a patent search at the provisional stage. I taught you guys how to do it. I think it's important to teach before you do the provisional. But generally, when we write provisional applications for our startup clients, we don't do a search before we write the provisional. We assume that they need speed, that they need to go fast. The search takes time. Oftentimes when we send that out to a searcher, we might not get it back for 3 or 4 weeks. It's going to hit our desk. It's going to take a week or two before it gets to our queue to be able to come to an analysis. And then $2,000, and 6 weeks later, we say, yep, let's go ahead and file a provisional. Most of the time, that's just a big waste of time and money, and so we just go straight to the provisional application. And so we don't even have that prior art to talk about in the background section. You guys did, and because you did it right after the patentability analysis, oftentimes that kind of same type of argument to overcome obviousness slipped into your patent applications. It's actually not necessary. What we're trying to do in our patent applications is to teach someone how to make and use it, not to convince someone that it's patentable. I also saw a bunch of statements in there of talking about, like, this is novel because, or this is unobvious because. That's certainly not the best place for that. Best place for that is later on in the office actions and responses that you guys are going to write, or a patent attorney will write for you. Yes?
So
If you don't do a prior art search, how do you know that what you're sending in isn't something that already exists?
Because you have a Stanford degree and you're working on this and you know that no one else is working on this. And there's a leap of faith there, but it's no different than the leap of faith that I did a patent search but didn't search the last 18 months. And so the patentability search isn't going to get you a fully accurate assessment anyways. It will allow you to figure out that, wow, this wasn't even close to patentable. And those situations are great, especially for you guys to go through that. Before you even talk to a patent attorney, is this even patentable? And for you to go through the process of, wow, I found something exactly like it. Glad I didn't waste my time and money. And so that should be on your hands, but when it comes to either writing a provisional with a law firm or turning around and writing a provisional yourself, that analysis, that work, should essentially be forgotten. It was a binary, should we go forward or not go forward?
And then as for the non-obviousness arguments, those don't ever appear in either the provisional or the regular patents?
Sometimes when it's like a small, minor improvement of a previous invention, I will talk about that exact invention in a background section. That happens maybe 2% of the time. I've done that maybe 10, 12 times in my career, and I've written 500 or 600 patent applications. So it's not going to happen very often. But in the situations where we're going to move forward, and it is a fairly minor, somewhat nuanced, somewhat slippery and subtle improvement, I want to just head off that particular obviousness attack right away. But that's actually more of like a novelty issue instead of an unobvious. I wouldn't ever talk about multiple pieces of prior art in a background section and how someone could combine them. I would never make those admissions in a background section. One of the other general themes that I saw, or I'll call them mistakes, but was a lack of trying to come up with these different abstraction layers. And so great development of very specific embodiments, but not a development of the layer above it that would talk about the particular invention in a generic way. And so coming up with that language is really important, because that's actually the language that you're going to use most likely in your claims. And so you're going to want to have that type of language in your specification. Any other questions, or any questions, on the provisional process or anything that we covered from last week or 2 weeks ago? Yeah.
Should provisional patents ever get taken up in court? What aspects of them, and whether they get called out for?
Yeah, so it's they themselves are not going to be examined. It's more of the full patent application that someone is trying to sue someone else on. And one of the defenses is that you shouldn't have gotten that earlier date of the provisional, and therefore when you don't get that date, there's now prior art that knocks out your patent application. And the way to attack that is to say that that provisional doesn't support, doesn't teach those claims that we're trying to claim later on in that patent application. That's the only thing the provisional does, is support those claims. And so that's why the concept of having a background section just doesn't even make sense. Sometimes when you're trying to convince investors through due diligence, hey, invest $1 million in my company, it's nice to have that background section, because just dropping the provisional application on them, they might, their brains might not be able to jump right into it. And so that background section I kind of use as like a entrance ramp into reading the document. But it's usually really short, like a paragraph. A lot of you guys did that, which was great. And some of which I saw, 6-page provisional applications and 3 pages were on a background. So effectively that provisional was 3 pages long, not 6. And potentially a bunch of things that could get you in trouble. Any other questions on the provisional process or the patentability versus infringement? Yeah.
Provisional, if you know, if you have some ideas that span a really broad range of methods of doing something, and you know that there's other patents at that level, and you're kind of down this tree, but you also have all these other ideas, should you cram all those into the provisional, thinking that, later we'll connect these two way out here, or should you just go down the tree that you actually developed further?
It's a really tricky question because there's another factor in there that needs to be thought of. And that factor is, as you expand to different areas and different industries, you're now allowing the examiner to introduce that prior art of that industry. Because you've said that this is your invention, and it encompasses medical devices and aeronautics and marine biology. And so now the examiner could just go in and be like, all right, I found something in aeronautics that's going to knock out your entire invention. And you're like, whoa, whoa, whoa. What I'm really inventing here is a medical device. And you're like, but you said right there in your patent application that this applies to everything, and so therefore one of skilled in the art would have thought of all of these industries, and I found something in this particular industry, and now they're going to use that against you as prior art. And it's really hard to argue against that. And so as we expand the reach of something, the flip side of getting that breadth and that value is the fact that we're now allowing the examiner to introduce that prior art. And so sometimes it's nice to have, in your case, maybe 5 different patent applications that have these little moats around them, so that if one of them goes down, they don't all go down. On the other hand, it's sometimes nice to be able to get that broader, higher level abstraction layer. And you can't get unless you put a bunch of these things together. The interesting thing here is I have in the past crafted both and filed both. So maybe we would file one patent application that covers effectively everything, and then we would, or say it another way, we'd file 3 different provisional applications separately, and then we'd file a 4th that combined all 3. It's an extra $125. You've already created the 3 documents, staple them all together or PDF them all together in one document, send it off again. It's an extra $125. Keep in mind that if you don't use a provisional application, it's never public information. It's abandoned. You can't find it. And so now this concept of trying to create these moats and whether or not to combine these, we'll just defer for a year. That's worked out fairly well in a couple situations. And my gut feeling on it turned out to be we ended up going the other direction. I thought that the silos would be a better idea, but we ended up grouping them all together and throwing them in one provisional, and it was that combined provisional that we ended up using. Anything else? Yeah.
A little bit this, but will you talk about hiring patent attorneys? What are the top 2 or 3 things to keep?
Yeah, I actually have a slide on this for our next question. The simple answer is they need to have kind of 3 things. They need to understand the technology. They need to understand generally the business. If you're in a startup, they need to know startups. And they need to have a decent amount of legal experience writing claims. Writing claims is really hard. At the end of today, I'm going to invite 2 of my patent agents. They're both Stanford grads here. And we'll talk a little bit about actually with the career path of a patent agent and patent attorney if you guys are interested. Because this lecture will be a little bit on the shorter side. Today we're talking about inventorship, ownership, and the concept of assigning and licensing. Eric Feldman?
Yes.
Eric. What are the facts in the inventorship portion of the Ethicon case?
Is this the case with Yoon and Choi? So Yoon and Choi works. What do you mean particularly?
Just not the result of it, but just hey, it's kind of set up. What happened? How did they get to the court case?
Yeah, so Yoon and Choi were working together, and the fact is that Choi dated Yoon in, I think, claim 33, and so that was the point of contention in the case. And the court used Choi's testimony and his sketches of the method for, I think it was some method for for opening part of the body cavity. They used his sketches for that claim to determine that he was.
That's perfect, right there. Determine what is going to be on the another question. So Yoon and Ethicon brought an infringement lawsuit against Surgical regarding a particular patent. The lower court ruled that Choi was an omitted co-inventor, that he should have been named as an inventor, but he was not. And Choi did not consent to the lawsuit against Surgical. Cesar Jenkins?
What was the test for inventorship here?
The test for inventorship is whether or not you contributed to the original idea, not that you helped prototype it or supported it in some way, but that you came up with whatever the line is.
Original in there and contributed in there, so you got those two kind of key phrases.
Concrete don't need more experimentation to reduce its practice.
Awesome. The test for inventorship is where the person has made an original contribution to at least one of the claims. All right, well, what is conception? Conception is a formation in the mind of the inventor of a definitive and permanent idea of the complete and operative invention. All right, well, what does that mean? It's complete and operative only when the idea is so clearly defined in the inventor's mind that only ordinary skill would be necessary to reduce the invention to practice without extensive research and experimentation. You can see here pretty clearly that it's a pretty slippery concept, and we keep on trying to define it with things, and those things that themselves are fairly slippery. I have a client right now that was working with another company, and they received an SBIR together. And the company that they were working with, her startup and this other startup, they had come up with this general concept of, hey, wouldn't it be great to use this sensor in this kind of a product? And they are the ones that are working on this particular sensor, and my client is more working on the product. And so when we filed a patent application earlier this summer, we filed it on the product. The idea that this other company gave was just a high-level concept. We didn't really talk about the exact sensor that they were using. We just called it a sensor. And these sensors have been around for a very long time. And we've been in a fight for a couple of months on whether or not they should be named as an inventor. And what I kept on going back to their patent attorney was, well, point to one of the claims that your client has actually contributed to. And they kept on going back and saying, well, paragraph 17, paragraphs 22 through 28, you keep on talking about a sensor embedded in this product. And I kept on saying, well, you need to point to a claim. They're like, well, we should be an author of this patent application. And at some point I got really frustrated and ended up looking up this other patent attorney, thinking that he actually wasn't a patent attorney at all. He was. He had 40 years experience, which was very, very confusing to me. They didn't understand this concept. But I bring this up just because this is pretty confusing. And another thing is that the claims can change. What he knew was that he either was playing stupid or he was playing clever. And I gave him the benefit of the doubt that he was playing clever. But if he would have told me that my client contributed to claim 16, what would we have done? We would have just canceled claim 16. And that's not what he wanted. Like, he wanted his client to be named as a co-inventor. And that's not what I wanted at all. And I didn't want that pretty bad. And so I wanted to force him to tell me what claim that his client was involved in. And all he kept on pointing to was the paragraphs that his client contributed to, knowing that that was a lot squishier than exactly a particular claim. I'll tell you how that story ends up later in the lecture. Peter Livingston? Yep. What's the holding of the inventorship portion of the Ethicon case?
Is holding defined as what did the court determine?
Yeah, exactly.
So they determined that Choi had contributed to two of the claims,
and therefore he was a co-inventor and had.
That's all we need to hear, right? That he was a co-inventor. It was just, I think it was actually just one, right? Is it one claim? Two? Oh, it's two. Okay. Two. How many claims were there?
More than 30, I think.
Yeah. A decent number, right? And so he just contributed to two. And that's enough to be considered a co-inventor? You know a little bit about claim structure now. How do you think that worked in terms of what that contribution was relative to the major invention?
Probably pretty minimal. Given that, it's like claim 33, so it's probably a pretty minor dependent claim.
It might have been an independent claim, but I think it actually was a dependent claim. And so it's adding something of a particular detail of that, possibly a detail that wasn't necessary. If they got the independent claim, did they need that dependent claim? So it's kind of strange when you think about this. So he makes, this particular inventor contributes to a dependent claim, to a detail that was inserted in a dependent claim. But the independent claim, the broader claim, was actually allowed. And so we didn't need that dependent claim in there. Because we didn't need that dependent claim, we could have left it off. And that would change the inventorship. What this other patent attorney was trying to argue, and I didn't buy any of it, was that the independent claim would read on a product that was encompassed by the contribution of his client. So if we would have taken out this dependent claim, claim 33, there was an independent claim that would have encompassed Troy's idea. That's actually not how inventorship works. And so had we taken out, even though it would have encompassed it in some way, the different layers of abstraction can actually have different inventorship. And the higher level of abstraction wouldn't include all of the inventors of the lower level of abstraction, which is a little counterintuitive. And I still haven't figured out if this patent attorney just didn't get it or if he was being super clever. But we got in a good argument. Troy conceived of at least one of the elements of the claims and therefore is a co-inventor. Thanks, Peter. There's a couple other aspects to inventorship and ownership, but at this point I want to just pause. I want you to turn to one of your neighbors and talk about this issue of, okay, so if you're thinking about acquiring a patent or licensing a patent, what would you ask the inventors to ensure that the proper inventors have been named? If you were a venture capitalist and you're about to invest in a company, what would you ask? If you were a startup, what answers would you want to make sure that you had when you were asked these questions? Yes?
As a question for context, if you acquire a patent and then you later find that something happens with, the Troy and Yoon case, are you liable completely, or can you go after the person who sold it to you?
Think about what's liable. So you didn't do anything wrong, but that patent might not be valid. Or there may be another co-inventor out there. And that co-inventor could end up screwing things up.
Right, but could you go after the person you bought it from? Or?
Oh, sure. That might be in the agreement that you had, that you guarantee the inventorship. And that you have a chance to go back and either sue them or you put some money in escrow or something along those lines. I've seen a deal structured somewhat similar to that. Great. We'll discuss this together in a few minutes, but turn to your neighbor right now.
say way out of the context. I've run into situations before out in the industry where you have people think they, when you have like 6 engineers in a room, someone has an idea, you go back later and go, okay, yeah, I had that idea. And we've had 6 different people all building on it and moving it around, brainstorming it. So I know you can do everything from, you'd ask like, okay, which vendors did you work with? Where did you buy the material from? Did they do any development on the process? Sometimes you make an invention, but the invention becomes like a made unless you have like a machinist for the way to make it. Or a builder or somebody who has specific technology to develop it to make it. In this case, it was a tech. It was a person that built it. A lot of times, engineers that come here, they'll kind of consider you lesser partners in an idea. Like, oh, they're just tech. It's like, well, no, I've known lots of techs who the product has never been made. It's not how they do all the work. You've got the tech, you've got the businessmen, you've got a lot of different people coming out. Reduction of practice. If you say, okay, I want to make an anti-gravity device, and it's going to float when you land, and then you hand the idea off to someone else and say, make it. And you find a way to make anti-gravity float.
All right. Group in the back. You guys. What's one question that you would ask?
Well, we would go through each individual claim and ask who helped you with this claim, and if there's ever one person that answers the mentorship question.
So you go claim by claim, but a lot of people don't understand claims. And a lot of people, like, their head starts to spin after about 3 or 4. And I say this based on good amount of experience. And so if you had 5 patents and they had on average 30, 40 claims in them, you're not going to get too far through that process, realistically. I mean, I think that that's an awesome answer, but realistically, it doesn't translate all that well to the real world of like trying to like walk through this. Yeah.
I would ask if there's anybody who potentially could claim to be a co-inventor. And then
What's an inventor?
What's that?
What's an inventor?
Okay. Whether there's anybody who could claim that he substantially helped with whatever idea they
What do you mean by substantially?
Anyway.
What do you mean by help? Does that include the secretary that's working in the company?
Sure. And then you can go through it and then ask the experienced patent attorney.
Well, there's about 100 different people. I got some friends. I bounce the idea off people.
But that is quick, right? They say, the second time we have something like, they say, okay, no problem, next one. So let's see how many people this time.
If you could look at, so you have certain people who are named as inventors. If you could look at any original design documents that they had previously before they worked with someone in the lab to do some research on it. If you have those documents that where no one else worked on it except the inventors.
So you ask them for their lab notebooks, and in the lab notebooks they don't mention anyone else. That might make sense, but there might be some other co-inventors out there that they just didn't mention in their lab notebooks. I mean, if they didn't draw like, Sherry helped me, and she, they drew a picture of Sherry and like contributing to one of the inventions or one aspect of it, right? What else? What do you guys say in the back?
I guess you would basically ask them like who, what, where, when, exactly how did the invention come about, like try to figure out if anybody would have helped in the conception. So.
What do you mean by conception?
Um,
I'm not trying to be a jerk. Like I'm trying to be like, this is realistic, because I mean, I went to law school. I knew the test, went to try to apply it, and they're just like, I don't know what conception means. Like contributed to one of the claims. What's a claim? Well, it's a part at the back. Here it is. I'll show you an example. I don't know how to read that. Well, let's not focus on that. Let's talk about the reduction of practice. What's that? I mean, these are all legal terms that you guys have somewhat of a handle on. And then when you actually try to apply this in the real world, like if you don't have a firm grasp of it, like it's just going to fall out. Like it's not going to work at all. And even if you did, it's still going to be pretty tricky. So one of the things that you might want to do is to talk about, all right, well, who helped you with this? Who was at that brainstorming session? When was that brainstorming session? What did the team look like back then? Did you have any outside consultants? Did anyone else help you with this? Where did they go with this in terms of, did anyone else kind of contribute along the way? And we try to use as much English language as we can instead of legalese. But this is hard. I've been in a due diligence situation where one of my clients was raising $20 million, and this conversation went on for 4 hours. And they were just hammering one of the inventors to try to figure out whether or not there was a co-inventor. And in that particular case, that particular company had received from one of the co-founders that ended up splitting off and then having some mental problems and then writing lots of letters back to the company saying that this was my idea, I can't believe you're tarnishing it, you're diluting my concept, and all of these other things. And so it was a big deal. We knew the problem, and we knew what the problem was going to be, but we were trying to decide whether or not this particular person was actually an inventor. And at the time, because he was a co-founder, they didn't actually have any type of IP transfer, which I strongly recommend even if you're starting a company with your best friend. You need to transfer that to the company. And as a venture capitalist, as an investor, angel investor, you're going to want to know, did this cleanly get from the inventors to the company? But then the other question that I'm asking here is, are there any inventors that didn't make it on this list? Yeah.
Around, if there is an inventor named on the patent that actually isn't an inventor, can't that also invalidate a patent?
It's not going to invalidate it. It's very rare does it just take down a patent, because
what are you doing in that situation? If you had more people than should have been there, but you collected all of their rights, maybe you collected rights that they didn't have. Maybe they shouldn't have been named as an inventor, but there's probably a couple of edge cases where maybe it was two different companies and you snuck their names onto as inventors to now co-own it, but they shouldn't have been on there in the first place. And so maybe the ownership is actually going to change because they shouldn't have been on there. But I don't think that the patent's going to be invalidated. I've never heard of that. It's mostly along the lines of, you did something wrong and you're malicious and we're going to invalidate it. But even in this case, this wasn't invalidated. It had a pretty catastrophic result for one of the companies, but it wasn't invalidated.
What institutions or companies you're involved with when you conceived of the patent? Were you a student at Stanford and working in a lab?
Yeah. So were there any other...
Were you working on a side project? Who was funding that side project? Who had IP rights to that side project? Yeah, definitely would want to know those things. It falls a little bit more on the ownership side than the inventorship side, but yeah, definitely.
Any non-disclosure agreements or any other agreements in the process of control?
Again, that will go a little bit towards ownership, not inventorship. Non-disclosure agreements, and I'll just kind of take a little time out to discuss that really quickly, is very different than IP transfer agreements. So a non-disclosure agreement is going to be exactly as it sounds, and as we break it down, don't disclose it, which is incredibly helpful when you have a patent right that could terminate or be prevented if you actually published it or disclose it. And so if you don't have a non-disclosure and you're talking about it, you might lose all of your foreign rights. You might start this 1-year grace period starting right then from that disclosure. And a non-disclosure agreement would say this isn't a disclosure. This discussion, I'm going to tell you about this, but this isn't a public disclosure because I'm actually saying there's rights around this conversation and you're not going to take it elsewhere. So a non-disclosure agreement or a confidentiality agreement is effectively this isn't a publication agreement. But a this isn't a publication agreement is not the same thing as I have all of your patent rights. So that if you were in a brainstorming session with a consultant and they signed a non-disclosure agreement, and then 6 months later you go to file a patent application, and we figure out, well, who are the inventors? And we start listing down the inventors, and we say, okay, well, this person over here, they don't actually work here. They work at J&J. That's fine. They signed a non-disclosure agreement. That's not fine. Because we now don't fully own this particular invention. That might not have been a public disclosure, but that didn't do anything for the ownership.
The person was hired, so I remember reading that if you are hired as an employee and you invent something, then that is owned by a company. So how does that apply for someone like a consultant who's like a temporary employee?
So the hiring, which is kind of are you referring to like the workshop, right? So there's some states, and this is state by state law. So this is not federal law. This is state by state. And I know Michigan and I know California a little bit. So in Michigan law, that if you hire someone and they invent something, but you don't actually grab their rights, you don't transfer the rights to you, you have a right to continue to do that invention in your shop. It's called like the workshop right. And you could go ahead and make that. You can't license that right to anyone else. You can't sell that right, but you could go ahead and make it. And this is a way for big companies effectively not to get screwed by someone else that would come in with someone else's invention. That's not the same thing, though, as transferring ownership. And that's certainly not the same thing on a state-by-state basis as an IP employment agreement. So most of you who have worked, and actually probably all of you that have signed, a good portion of you have probably signed the Stanford IP agreement that first day, or to get your grades, or to pay for tuition. And sometimes you know what you're signing, and sometimes you don't. But effectively, it's like anything that I come up with here is now owned by this employee. And on a state-by-state basis, some states will interpret that to be pretty much all-encompassing. If you're working at General Motors and you came up with a refrigerator, that's included. Michigan state law is going to interpret that pretty broadly. In California, that would never fly. So something that you were doing on your own time with your own resources that wasn't directly related to exactly what you were hired to do by that particular company, then there's a good argument that that's your invention. We're going to confuse things a little bit here when we flip over to ownership. Or is there any other questions on inventorship? Okay. Nikita? What are the facts of the ownership portion of the Ethicon case?
I'm not sure on all the facts. The U.S. Surgery signed a license agreement with what's his name? Engineer, I think Choi, which after the fact, which allowed U.S. Surgery the use of the invention starting from the patents issuance.
So this part of it is actually relatively confusing. You did a great job. Yoon signed his rights to Ethicon. Surgical infringed. Choi, an omitted inventor, offered Surgical a retroactive license to the patents. Surin?
Here.
What's the holding of this? Whatever happened on the ownership side?
So we know kind of leading up to it, a retroactive license. Did the retroactive license work?
I'll pass on it.
What's that?
Don't remember. I'll pass on it.
Okay. Is there anything else that you could remember about this case? How it all ended up?
I think we won. Infringement.
We had a 50-50 chance on that. A little bit more, give you some credit.
It's okay. I just remember that.
Who could help out?
I think it was actually upheld that the retroactive licensing would not work, but then I think it was actually dismissed because Choi did not show up as one of the plaintiffs from the side of the owners of the patent to say that U.S. Surgical did indeed infringe on the patent.
What's your name?
Ram Sivasankar.
So the retroactive license didn't work. That you can only give a license prospectively into the future. You can't release a party from past infringement against one of the other co-inventors. But they both must actually agree to bring the lawsuit in the first place. And Choi never agreed to that. And so effectively the same thing worked out. Because Choi was never asked, and Choi can now say, no, thank you, I don't want to bring this lawsuit, then the case is going to be dismissed. What do you think actually happened here?
I think the U.S. Surgical knew they were being sued for infringement, so they went out and did some due diligence to find out if there were anyone else who would possibly be a co-inventor. They went and found Choi and said, hey, Choi, you want some money? He said, by the way, do you know you're a co-inventor?
I think that's exactly what happened.
I think Choi may not have known he was even a co-inventor.
How much money do you think they had to pay Choi?
He was only a technician, and he probably wasn't thinking. I mean, this was a big high-up doctor who had worked with him for a little while and then dismissed him. So, maybe $50K.
Maybe that's the right number. Maybe it's actually even less than that, because he felt that he was scorned with the whole concept of not being named in the first place, and so he might have done it for free. He might have, if he was smart, maybe he would have said, you're being sued for $1 billion. How about $900 million?
It's like Ethicon. I would have asked for quite a bit more.
And so it actually would be even worth more than $900 million, because this is Surgical Pain is their competitor. So it's $1 billion out of their pocket going $1 billion into the pocket of a competitor. It might have been worth even more than the lawsuit, just so that they didn't have to pay their competitor that exact money. So I think it could have been a tremendous amount of money. Maybe they had a couple of different options, and so they were able to negotiate $50K. Maybe they got them the agreement, and $50K sounded like a great idea. Hey, we want to get you named as an inventor. We want to do the right thing. Can you sign this? And then could you sign an agreement not to participate in the lawsuit? Here's $50,000. And they just got out of $1 billion lawsuit. If you were Surgical, would that have been a good idea? Yeah. $1 billion saved, and your competitor doesn't have an extra $1 billion that you had previously. So a lot of times my clients will say, well, how is anyone really going to know? This stuff is somewhat subjective, and we've listed 4. It may be that this other 5th inventor should be listed. It's kind of tough to tell, but we never got their IP rights, so let's just not include that person. And the patent office isn't going to know. The patent office isn't going to care. The patent office, they don't have the ability to do this due diligence check. But if this is worth $1 billion lawsuit someday, that's going to come out. And the fact that one of the inventors was either scorned or omitted or maliciously just kind of excused from this list of inventors, that's going to come out. And your ability to bring that lawsuit to clamp down on one of your competitors and beat them up could be completely diffused by the fact that you didn't get the inventorship right.
Because if I'm part of a company and I invent something, if my name is on the patent, I'm not getting anything from that because the company owns it. So all of the money goes to the company. Maybe I have $1,000 bonus or whatever. But maybe it's best to be omitted on that patent so that later.
So it depends. So if you were actually part of that, you had an IP employment agreement, it doesn't matter if you signed it then or you turn out to be an inventor later on. So Troy didn't sign that agreement, obviously. Because if Troy had, then it didn't matter where along this path we decided to add Troy back. Troy would have gone back, he would have had rights, and those rights would have automatically transferred to Ethicon.
Okay, so only the owner can trigger a lawsuit or do anything with that patent. Right. The inventor has only the name on the paper. Right.
This is a little bit different in Japan, from what I understand. I'm not an expert in Japanese patent law, but from what I understand, there's something different about the way that inventors can participate or choose not to participate in lawsuits, infringement lawsuits. But for a U.S. law, that's exactly right.
So I guess I'm a little confused. In the book, it mentions at some point that the co-inventor has 100% of the rights. But apparently you don't have the right by yourself to sue someone, right, for infringement. So you don't have all the right by yourself.
But it's difficult to... So the 100% kind of more refers to the concept of if you were to license it for money. And so now you're licensing your rights to someone else, and they're paying you $50,000 a month for that patent. You don't actually have to give it to one of your other co-inventors. If your name was on that agreement and some other party, and that party agreed to pay you, then that's enough. It's effectively that other party is saying, I don't want you to sign on to the right of a lawsuit against me. And that's really what a license is, and we're kind of building up to this. That a license is a right not to be sued. And you could get that right from any of the inventors, as we now see. And it wasn't necessarily retroactive, but it was a right not to be sued, and that Choi never actually signed on to that lawsuit. And so that would be on more of the positive on the enforcement side. You'd have to get all of them. Yeah.
Why wouldn't Ethicon offer Choi more money than U.S. Surgical was offering?
They may not have known. They may not have known that this was happening. But clearly, it would have been worth to them if they're trying to bring $1 billion lawsuit to make sure that they got this right. Maybe this gets made into a movie someday. This actually is not an uncommon scenario. Yeah. So I think I goes back later and says, oh my God, we totally messed up. There was someone else in the lab, and that person didn't sign an IP agreement, and they contributed to one of these claims. And we need to go back and grab those rights. Because if we don't grab those rights, then Surgical could. And if Surgical could, then this entire lawsuit goes away. So maybe that was maybe there was a bidding war there and Surgical won. If that particular inventor was scorned, that they felt like they should have been on that patent in the first place, it may not have mattered how much money Ethicon was offering. The concept, and it gets strange, but I've seen this over and over again. Like the emotions around patents, for some reason the egos and emotions kind of get involved in that. And when you get omitted and you felt like you should have been, and then it turns out that that patent was worth $1 billion, and he had contributed part of it, there may not have been any money that Ethicon could have paid him. Any amount. This happens a lot. Early stage companies do a lot of brainstorming with other people. This happens all the time in biodesign. This happens all the time in the D School. And these are just two places that I know a lot about. And so this is something that we want to brainstorm with others. We want to have this multidisciplinary approach. This is how great inventions come to life. And we don't always have all of those people in our company. We want to have great advisors that are contributing. But this kind of stuff happens a lot. And how do we figure out whether or not they actually made a contribution to that invention? How do we get in writing that they did or did not? This is a rather big deal. So to close up the story that I started earlier, it turns out that the two companies have now come to some business agreement that the other company is not going to push hard to be listed as an inventor. And in exchange, they're going to get a non-exclusive license from my client. What's the problem with that?
They can change their mind.
Yes, they could change their mind, and why can they change their mind? It's because inventorship is just what it is. It's not like what you agree to. And this is actually a really, really important concept. That we could say that, well, we agreed that he was not an inventor, or we agreed that we were both inventors. That actually doesn't work. It's who made an original contribution to at least one of the claims. That is what the inventorship. And we can't agree otherwise. We could agree that we're both inventors and we're both going to give rights to meet. We could agree to that. But we can't agree on who the inventors are. The inventors are who the inventors are. There's a legal test for that. We could agree to what happens after that, but we can't agree to who the inventors are. And so in my particular case, that's great that they came up with this business arrangement, but I need to go back and dot those I's and cross those T's and say, I need a statement that says that you're not an inventor, that you didn't make any original contribution to any of these claims. And only in that situation can I move forward with a decent amount of comfort that they're not going to change their mind.
So why not do it the other way? Why not have them inventors and then do the business agreement of they'll sign their
I was pushing for that. Go ahead and be listed. More the merrier. It's not going to invalidate this particular patent. And now they assign their rights, their ownership rights, and then we turn around and give them non-exclusive license. I actually like that a heck of a lot better. And ultimately, I'll probably push for something very similar to that. Because if they can't sign that statement that says that they're not an inventor, then we have to go down that path. Because the inventorship is wrong. It doesn't matter who owns it. Ultimately, if the inventorship is wrong, we see from this case that it doesn't matter what the agreement was supposed to be, that if the inventorship was wrong, the ownership can change.
But if you fix an inventorship, couldn't that other person from the other company just give that company rights to produce whatever it is? They wouldn't pay you for rights to produce.
But we could have an agreement around that. So we could say that, all right, we contributed, they contributed, all of those patent rights go to my client's company, and then my client's company, actually it would go to their company first. I see where you're getting at. And so if this is the inventorship, and this is my client, it's a funny-legged other company. And so this is my client, and this is them. So my client inventorship goes over here to my client, and this inventorship is going to go through an employment agreement to this other company, and then we would turn around and get ownership of that, and then turn around and give a license back to this other company.
But why would they pay to get the license back when they have the ownership to begin with? use it? Is it just
It's because of the, yeah, it's this concept of like, well, if they are actually an inventor, they're going to have to tell us what claim they contributed to, and we could just delete that claim. And so they don't really have a ton of bargaining power because they could just simply, because whatever argument they make, well, we actually contributed to claim 18, great, delete claim 18. And so whatever they actually say, as like this is our argument for ownership, I could just trump that by just canceling that claim. And so I may not want to cancel that claim. It might be actually worth being in there. And so this might not be a bad arrangement. This gives us ownership of the patents with the correct inventorship and all the claims that I wanted in there in the first place. But I don't want them to own it because I don't want them to license one of our competitors. Because if this happens and we're competing against one company over here, and then because they now have a co-inventor, and because they now co-own it without any agreement otherwise, they could turn around and license one of our competitors. And because the patent now doesn't have a unanimous vote on like who to sue, then this company we could never sue because this person gave them rights not to be sued. And I want to avoid that. That's what I wanted to avoid like from the very beginning.
I understand that they don't have a ton of bargaining power, but what's their incentive to agree to this?
Well, they have the two companies want to move forward harmoniously, but there's this little riff of this concept. We tried to structure this patent application without involving them. We didn't want to have a jointly owned patent application moving forward. We wanted our own. We're raising money, and an investor isn't particularly keen of having the core patent co-owned by someone else. And so we wanted really bad to have just ownership of it, but they didn't want to be sued by it someday. And so they didn't want to be stopped from working with other people. And so if they decided to go down that path. Any questions on this stuff? Relatively complex. It turned out, worked out just fine in this particular case, talking about the story. But this issue is a relatively big issue. It's very real. This is just the example that I had that drew from the last 2 weeks. This happens a lot. And this definitely happens a lot on large campuses like this one. So where do these ownership issues arise? Any other questions out there? Long-term relationship with suppliers and third parties, joint development, which is exactly the example that I gave earlier, licenses, joint ventures, supply agreements, purchase orders with customers and suppliers, handling of confidential technology. And so these are kind of like non-disclosure agreements. Again, non-disclosure agreements don't cover any IP. And again, in a university research setting, this happens quite often. How do we actually prevent some of these things from happening? So what would you recommend to your client about this particular issue to prevent this from happening? But who's going to sign that? So you wanted to get some big name folks to help contribute to your invention. And they're signing on as advisors. One of them works for Medtronic. Another one works at Stanford here as a position here. And you push a piece of paper in front of them that says, anything that you contribute that has anything to do with the startup that I'm working on belongs to us. How well does that go over?
So non-disclosure agreements actually hard. It's not.
But this is different than a non-disclosure agreement, right?
Right.
So non-disclosure agreement is only, I'm not going to talk about it.
Right.
This is an inventorship agreement that anything that I invent that's related to your startup is yours.
So what could happen is offering a percent of, whatever, if there is a revenue or something else of it in the future.
Yeah, and so maybe you're bringing on and you're recognizing some advisors. You're saying, look, we know that you're going to contribute. We want you to contribute. We want you to be involved. We're going to pay you to be involved. We're going to pay you in equity. And in exchange for that, we want you there brainstorming. And of course, we're going to want those inventions. We need ownership of those inventions to be able to move forward and to be able to raise money. And so that's one way of doing it. But it's tough because you don't really know whether or not those advisors are going to be any good. And here you're giving them equity before they've even brainstormed. But if you do it after they brainstorm, then that's possibly too late. And so that gets a little tricky. And they don't want to sign on board to give you all these great inventions when they don't know if you're going to be successful or not. They don't know if that's 0.25% or 0.5% is going to be worth anything someday. And so they just want to be there and have fun and brainstorm. And it doesn't matter until it gets really serious. And this is kind of like a reoccurring theme in patent law of just it doesn't matter unless it really, really, really matters. And when it really, really matters, you better have done it right. In all other situations where it didn't matter because it wasn't worth anything, then of course it didn't matter. No one's going to argue about that. And so you're now just kind of putting a glass ceiling on how good your ideas could be. Because if they tried to bust through that, then they're stopped because you didn't get the inventorship right. Yeah.
Kind of a gating period where you ask advisors for advice, telling very precisely that you don't want them to invent anything, that there's this ownership issue, that everything you do belongs to Stanford if you're at Stanford or whatever, and that they're not inventing. You really enforce that they shouldn't invent anything, but just give you advice on specific questions. And then once you really go in a brainstorming room and say, okay, now we are brainstorming, at that point you must have solved that before.
I think that's the answer. But that gets a little tricky. And the tricky part of that is that people like to throw ideas out all the time. They like to hear their own ideas reflect back. They like to hear their own ideas get the thumbs up. They want that. And especially people that you want as advisors are going to be those exact kind of people that ideas just spew from them. And then that's who you want as an advisor, and that's actually pretty dangerous. Well, I gave you that idea. And then I started another company, and I patented that idea. Or we ended up both patenting at the same time. Or we were dating, and then I gave you this great idea, and then you didn't give me an advisory role, and I didn't get any equity, and so I was bummed about that. But you took my idea and patented it, and now you're worth, $500 million. I think I'm worth 2% of that. I only want 2%. These are real-world examples that I'm throwing around. And so I think that the answer here is make sure you understand when you're brainstorming. And make sure you give this some thought as to, did we collect all of these people's rights before we get in this brainstorming room? And if you're not in the brainstorming room, you're not inventing. I don't want to hear it just yet. I'm sure that's a great idea, but let's talk about that later after we've decided how we're going to handle ownership. Yeah, that sounds great. I'm sure that's a great idea, but please, let's wait until later on.
Starting a career out, you have to sign some pretty draconian agreements handing any and all rights over. When do you know, obviously if you have a high-powered advisor with multiple businesses that own a patent portfolio, they're not going to sign that. When do you make that switch between, I need a job, Stanford's not going to let me come here and study if I don't sign this, to, no, I want a percentage now?
You're probably never going to be able to negotiate that. With respect to directly, that's that employment agreement that you sign that first day, whether it's at Google or Stanford or anywhere else. There's very little negotiation of that, and lawyers present it in that way, and it's usually the first day, and there's so much excitement to get through the door, and then they just put the pen in front of you, and you just sign, and you don't even know what you're signing. And if you put up a stink before that, that might be the end of that part of your career, right there. because they're willing to say, like, this person's not the right person. We haven't invested any time in this person. And this is exactly why you signed it on the first day. And so there are certain situations that you could get around, not necessarily get around, but you can minimize some of this. Nearly all of those types of agreements, you can list out all the previous inventions that you had. And say, like, all right, I agree that during this particular period that any idea that I have that's related to the work that I'm doing here that's on, using your resources, I agree to sign over to you. Except these 12 ideas that I've already started on, that I've already worked on, that are documented in these particular lab notebooks. That might actually be one good reason to continue to use lab notebooks after we move to a first-to-file system.
Does that count as disclosure?
Titles usually don't. Because you're not teaching anything in the title.
Sometimes you are. The double extrusion of the soy thing. That might be a public disclosure because that idea was so simple. But everything else is typically not disclosed in the title.
But those are confidential documents, aren't they?
But I don't know if like that other company that they would say, if they could use that as a public disclosure, they probably would. They're not going to assign that is a non-disclosure agreement on top of that. I don't think you're going to get your lawyer in there to make HR sign that. I don't think that's going to work. Yeah.
Practically, this is all very awkward, though. Right?
That's a great that's a great one-word description of this lecture.
Just from my experience, when you start working on these projects, and I worked with a cardiac surgeon who's been in the field for a long time, and he's this old guy, and I'm not going to walk in there and say, it's great to hear what you think about it, but I don't really want to hear as an invention, or if you do talk about can you sign, it's just, and I understand that down the road this might turn out to be a horrible mistake, but it's just at the moment, you never think of the idea as being worth that awkwardness.
I view myself as a pretty practical attorney, and I think that all my clients would describe me as that, very pragmatic. And so, this is the law, and then how do we apply this in real life? And we do our best to be able to say, we're going to have a brainstorming session on this date. We had our lawyers draft up a quick assignment of anything that comes out of that brainstorming session. And so now we're defining it by time and by place, and so it's a lot easier for them to realize, I am contributing during that time, and they're asking me to contribute, and then when I contribute during that time, like anything that comes up during that time is theirs. I agree to that. That makes sense to me. And so that's one way to kind of make this thing a little bit more palatable for people in that particular position. Otherwise, you need to be very careful about what other people contribute. This isn't just early stage companies with advisors. This is also an early stage company that is now taking a lean startup approach and going out and talking to customers. And those customers are saying, yeah, this is great, but what I'd really like to see is this. Yeah, that's a great invention. That's a great idea. Is that customer now an inventor? And so lean startups have this same kind of problem, but they're using their customers as kind of the advisors. And the more customers you talk to, the more you get out of the building, great. We all know who Steve Blank is and what he espouses. That's awesome. But that's also problematic. And that if you're having long discussions with your customers and your customers are talking about what they'd like to see and how you should do that, that starts to become a little problematic. I'm not in any way advising you to just stay in the lab and don't talk to anyone. That's not what I'm recommending. It's important to have a kind of multidisciplinary, multi-person approach. That is where inventions come from. When I look back on all the great inventions that I've worked on and had the honor of writing patent applications on, a good percentage of those were multidisciplinary teams. And so that is really important. But all I'm saying is just be armed with the information of what does this mean? And what kind of a risk is this? Is this the type of person that's going to sue me later on? If I turn around and grab this idea from them, but don't give them something in return, like what's going to happen to that 10 years from now if we're successful? Startups are all about mitigating risk. There's plenty of things that could kill startups. And this isn't going to kill you. It's just like going to completely deflate the value of one asset that you thought that you really had.
Is it possible in these sort of situations to just make sure there's no evidence, or is it illegal?
It's a great question. So
there's no way to come back later and say I contributed. Right?
It's a great question, and it actually gets much more difficult when people start like emailing, hey, I had this great idea in the middle of the night, and they email you. That sucks, right? Because it's like, all right, well, we know the date stamp, and we know the person. And then you filed a patent application 6 weeks later, and you didn't include that person as an inventor. That looks really bad. But if this was just a verbal conversation, they're going to have a lot harder time saying, I gave you that idea. I agree. Often it's great, and oftentimes that all of our clients take photos of whiteboards. Why not? And they have in their calendar all the people that were invited to that meeting. This person was invited to the meeting, and here's the whiteboard. That's evidence, right? And so we could try to minimize that. And I agree with you that that's a great thing to do, but I don't think that it's completely possible.
In your case, the surgeon probably assigned his IP to his own academic center with Stanford or whatever. So he doesn't own it already. So he couldn't assign it to you. And you assigned it to Stanford. So then...
Those are actually the worst cases because they don't even care. Right? So we have some Googleites, or Googlers, moonlighting and helping out some startups. They're not really thinking about IP. They're not in there to get the IP. They're not in there to later on, sue the company. But when Google goes to acquire the company and they're doing a little bit of due diligence, and it's like, wait a second, we own all this IP. Just what happened to the valuation there? I don't have a solution. But what I do want you guys to move forward with is an understanding of these risks. And to do your best to minimize these particular risks. And then to just continue to move forward. Again, I'm not suggesting that you hole yourself up into a tiny lab and not talk to anyone and unplug all the phones and turn off your iPhones. I'm not recommending that. But just be very aware of what's happening. If you can segment, this is an advisory based on business, and we're going to have a separate invention brainstorming session where we're going to capture the IP of that, that's ideal. And sometimes that could actually happen, and it sometimes works. You'll see these particular words, and I want you to just make sure that you understand what they mean. An assignment is a sale. You assign it from someone to someone else. This is going in and buying a car. The title transfers. And in fact, this is actually what we do at the Patent Office. The Patent Office has a title place where you go and you register the title change. That this particular patent has now moved from ownership from this particular entity to this other entity. And that's what you register. You record that assignment. And that's effectively a title change. And if you bought a house, if you bought a car, you understand this concept that there is a place that provides this record or database of who owns what. And there's certain rights that if a second or third party would have if they bought a patent that wasn't actually owned anymore by that owner because they sold it to someone else, but that other person hadn't recorded it yet. This is exactly like a housing situation. And so you have a certain period of time to record that title change. And so when we get the assignments from our clients, from the employees to the company, we turn around and we record that quickly and efficiently. And it's right there now in a database where other people could go look. And they could do a search on like, well, what does Mission Motors own? And they could figure that out. Because we needed to record that particular assignment. Sometimes when you go into the assignment database, you'll see banks owning things. This is usually just that particular asset, that particular patent, used as collateral for a loan. Banks typically aren't in the business of collecting patents or licensing patents or anything like that. But this is just now there's some kind of security on that. There's a lien on that. This is an asset, and you went to a bank to ask for a loan, and they use this asset as collateral. If we default on our loan, then you now can take these patents. It's an asset. And there's a recordation of that asset in the form of a lien on that asset at the patent office. The person who owns it before they assign it is called the assignor. The person who gets it is the assignee. The assignee is actually the field that you'll often see on the front page of a patent application. Who is the assignee at the time of issuance? Yeah, sure. I could assign a patent to two different parties, and now they co-own it. That would certainly look more like a license. So ownership is the concept of that you have the ability to do and collect a royalty from this. You have the ability to give other people the right not to be sued. Well, there was a question that came up in an email to me last night about what's the difference between, or can an exclusive licensee bring a lawsuit? And typically, if you can bring a lawsuit, then that's considered to be ownership of that patent. That the concept of having so much rights to a particular patent that you could actually sue someone is typically considered you now own that particular patent. And it's usually one of the few distinguishing aspects of an exclusive license and ownership. Can you bring a lawsuit?
Point about the banks owning these. So what happens in cases like bankruptcy or foreclosure? I mean, you think there's an asset over there. Do patents just become like abandoned houses? I mean, are there abandoned patents? Are there people who make a business out of scooping up abandoned patents? Or
I suspect that there are a few abandoned patents, like there are abandoned houses, but that most of them, it's an asset. A lot of startups don't own much anymore. What are you going to do? Sell a laptop that was personally bought by that person? Yeah, like there's like a bunch of IKEA desks. I mean, like, what do you have? And
then how do you determine the value? If the startup is completely failing and no one wants to buy it, no one wants to fund it,
the terrible answer is that they often end up in the hands of a patent troll. Because someone's going to buy that on a fire sale. All right, so you guys spent $30,000-$40,000 getting this patent. We'll give you $50,000. It's an issued patent, or we'll give you $10,000. It's typically not. We'll give you the $1 million or 1.5. The investor views it as, well, what the heck are we going to do with a patent? They don't typically have another. Sometimes they do. Another company in their portfolio that's doing the same exact thing that would actually benefit from that patent. So there's a marketplace for patents. Doesn't really exist all that well. I'll take a little tangent to answer that, or why not. And that's because it's very difficult. And the value of a patent is typically the value of not being sued because you're actually doing it. And so the value of a patent to you versus the value of that same patent to someone else might be different by several orders of magnitude. Because this is the core to your business and it's not core to your business, something along those lines. And so what they're trying to do is someone's trying to scoop that up and then turn around and find who's doing that, who's infringing, and then sell it to someone who is good at bringing lawsuits against companies. So it transfers a couple of times. But one of the ways that patents get in the hands of a patent troll is through failed startups.
I have a follow-up question to something you just mentioned. So you said the value of the patent is typically the value of not being sued, but then I remember in the previous lecture when you were talking about infringement, you said the patent doesn't guarantee that, has nothing to do with infringement. If you get granted a patent, that doesn't mean that you...
So not being sued by a patent holder of that particular patent. And so it doesn't give you the right to not be held as an infringer of other patents. Yeah, thanks for clarifying that.
We talked about assigning a patent to multiple people sometime back.
That doesn't really happen. It was a hypothetical question. The answer is it could happen.
And sometimes in a situation where there's a joint development agreement, it does happen. Maybe 7 or 8 of the patents that I've worked on have fallen into the situation where it was a product of a joint development between 2 companies, and they agreed to co-own it. And so it does happen, but it doesn't happen very often.
It would more likely would be the case where one
company is licensing another. And so this is effectively, I'm not going to sue you, and so I'll give you this right. And if I'm giving just one person that right, then that would be an exclusive license. If we agree, I'm not going to give anyone else that right. That would be considered an exclusive. If we don't specifically agree that I'm not going to give anyone else that right, then it's a non-exclusive. I'm giving you the right not to be sued by me. It's kind of a convoluted way of talking about licensing, but that's really what it is. Because you don't have the right to make it. I'm not giving you the right to make this. I can't give you the right to make it. All I could give you is the right not to be sued by me if I have the patent. That license could be split up a bunch of different ways. It could last a particular period of time. You have a license to this for the next 2 years. You have the right to make this on Tuesdays. You have the right to sell it east of the Mississippi. You have the right to this outside of the United States. You have the right to this in this particular field. You have the right to do this with this particular industry. You have the right to be a supplier of this, but not a original manufacturer of this. You can't go directly to consumers, but you can be a middle person on this particular right. It's an agreement, and because you could agree to just about anything, then great. That's what a license can be. A lot of times people like to think of a license as just like one set of rights, but in reality, you could structure this however you need to structure it from a business point of view. You might have a balloon payment. Give me $1 million and you could use this for as long as you want. You might have something in reverse, that you could go ahead and use this for 5 years, and at the end of 5 years, you owe me $10 million. You might say that it gets cheaper. As more and more that you sell, it gets cheaper and cheaper. It's 5% for the first 1,000 units and 4% for the next 10,000 units. It might get more expensive as they sell more and more. That might be based on revenue. It might be based on profit. It's effectively whatever makes sense from your business, that's what you could turn on and create. The analogy between assigning and licensing is essentially the analogy of buying and renting. You have certain rights as a renter, but you don't have ownership rights. You probably don't have the right as a renter to sue someone for breaking a window in your house that you rent. If they damage some of your goods, maybe. But if it was just the structure itself, as a renter, you probably don't have that right. That's more along the right of an owner. Yes?
So if I have a patent that I license to you, and then someone sues me for infringing on their patent, can they dig into the profits that you've made off of the license of my patent?
So what did I do wrong? And what did you... Sorry.
Okay,
say that again.
Sorry. So let's say I have a patent which I license to you. Now you use this to make a product which you're making profit off of. Later on, someone tries to sue me for infringing on their patent.
You didn't actually do anything, right? So infringement of a patent is make, use, or sell. And if you didn't make, use, or sell, they can sue me, of course, because I was the one who made it.
Oh, okay. Okay. So the
and
license.
I might turn back to you and say, whoa, what just happened here? I thought that I could go ahead and make this thing. And you're like, no, I just gave you a license not to be sued. I didn't give you a license to make it. And so it's like, all right, so sometimes large businesses will want an indemnification clause. I'm going to take out this license from you, but you're going to indemnify me if I ever actually if I'm sued for infringement. And this gets a little tricky for startups working with very large companies, because of course they want to sign those agreements. And those agreements sometimes have this indemnity clause in there that says, all right, well, we're a gigantic company. If we infringe, then we're going to turn to you for all of those infringement damages. And it's like, whoa, so we're this tiny little company, and we're going to make a little bit of money off of this license. And when you go out there and make this, you're the big bad company that's making a ton of money off of this. And when someone sues you for infringement, that's a ton of money. And why are we held liable for that? There's a quick little tangent before I wrap up this part of the lecture. A great way to minimize that is to say, let's cap it at some level. Let's cap the indemnification at whatever amount we collected as royalties, or 2x royalties, or 5x royalties, or something. I had a client that got into a situation where it was an uncapped indemnification, and we didn't get an investor to come on board when we needed to because they were concerned about this particular issue.
So if any of the owners patent and license patent, what happens regarding licensing?
Well, that startup, that company is not going to get funded because all these rights could go in different directions. And that's why the investor will want to make sure that all of these rights are collected into one entity. It might just be one person, but as long as it's one entity and not multiple entities, then that's great, because there's no more conflict. And so typically, an investor won't come on board until an entity is created and all of those rights are collected in that entity. Great. So I'm going to wind down this part of the lecture. I want to talk a little bit about patent prosecution, patent agents, and patent attorneys. And I will wind down the recorded lecture, but if you guys want to stay and hear about what patent attorneys and patent agents do and how to interact with them, please stay.
For more, please visit us at stanford.edu.